Hello, all of you. We are discussing the RTI Amendment Bill 2019. Now the bill has turned into the Act, so here we'll call it Act. Now, before we start to discuss the proposed changes by the bill, what this Act actually did, let us try to first of all analyze and understand very briefly that what RTI is all about and what was the purpose behind this very RTI Act of 2005 when it was brought. So here we go. The RTI Amendment Act 2019, the original bill was passed in 2005 by the then UPA1 government, under which the public authorities are required to make disclosures on various aspects of their structure and functioning. So this was seen as an attempt to enhance accountability and to further democracy, to increase transparency and democracy. Now, what all it included: disclosure on their organization, functions and structure, powers and duties of its officers and employees, and financial information that pertains to their office. So as you can clearly see, this is what the original act was brought for, and it has proved to be a big time game changer in India. It has delivered good governance to a large extent. It has facilitated democracy and governance, and of course it has held the public authorities liable for the actions that they do. So anyone can file an RTI and access the information. And information today essentially translates into empowerment. So this is a very good act which was brought in 2005. Now the current government has done certain amendments which we shall very soon see. So again, briefly seeing the intent behind this act to promote transparency and accountability in the working of public authorities, because this was much needed, and public authorities, it's a quite bulky slide, but we'll see it very soon. It includes bodies of self-government which is established under the constitution or under any law or government notification. For instance, these include ministries, public sector undertakings and regulator. It also includes any entities owned, controlled or substantially financed, and non-government organizations substantially financed directly or indirectly by funds provided by the government. This is how the Bare Act, this is how the official gazette of the government defines public authority. You don't have to remember this. You just need to recall, you just need to be aware of the fact that wherever the exchequer money is involved, that is it. Wherever the taxpayer money or the government money is involved, that can be called as public authority, because it includes substantially financed and non NGOs as well, which are substantially financed directly or indirectly by government funds. So that's why I said that wherever the public money is involved, that would be an authority. So what does the Right to Information Act 2019 propose? It changes the terms and conditions of service of the CIC and the information commissioners at the center and in states. See, CIC is the head, Chief Information Commission, and then we have state information commissioners, which are functioning in every state. So it proposes a change in their terms and conditions, the service of their terms and conditions of their service. Now, center shall have the power to set the salaries and service conditions of information commissioners at central as well as the state level. Now, some people see it as an attack on federalism, because center, the union government, will be taking a call on the state information commissioners. One of the apprehensions that is with this amendment. Now, term of the CIC, that is the Central Chief Information Commissioner and the Information Commissioner, appointment will be for such term as may be prescribed by the central government. So the appointment again will be decided by the central government. Now, what are the changes that have been brought through this amendment? If you read section 13 of the original act, that is the act that was passed in 2005, it sets the term of the Central Chief Information Commissioner and Information Commissioners at 5 years or until the age of 65 years, whichever is earlier. Now, post-amendment, appointment will be for such term as may be prescribed by the central government. So you can clearly see the change. It was earlier set for 5 years or 65 years of age, whichever the person attains earlier. But then now it will be totally on the whims and fancies of the central government. So CIC will be largely not entirely dependent on the central government. Now, the second change, salaries, allowances, and other terms of service of the Chief Information Commissioner shall be the same as that of the CEC, and those of an Information Commissioner shall be the same as that of an Election Commissioner. Now, looking at this point, this is the change that has been brought. Now, Election Commissioner is a constitutional office. However, Information Commissioner, the CIC is not. So here we can see that an attempt has been made in right direction, where they have been elevated at the level of a constitutional office. But then see the next point, because there was a parliamentary committee recommendation, and post this amendment, this was the original the salaries, allowance of and other terms of service of the Chief Information Commissioner shall be the same as that of the Chief Election Commissioner, and those of an Information Commissioner shall be the same as that of an Election Commissioner. This was the original act which was passed in 2005. Now, after this amendment, entire thing, the salary, allowance, and other terms of CIC and all the other election commissioner shall be such as may be prescribed by the central government. So it will not be equal to the Chief Election Commissioner. Now, Chief Election Commissioner gets a fixed salary. Chief Election Commissioner, the Election Commission itself is a constitutional office. So the original act equated a non-constitutional body in terms, the non-constitutional body here is the Information Commissioner, the CIC and all. So the original act brought it at par with a constitutional body in terms of the service, terms of service related to salaries and allowances. But now with this amendment, it will not be equal to the salaries and allowances and other terms of service with the election commissioner, but it will be decided by the central government. So you see the dependency on central government would increase. Now amendment also allows the central government to control through rules the terms of conditions of appointment of commissioners in the state. Again, even the state information commissioners will be dependent on the central government. Now, further the changes, status of the CIC has been brought on par with the EC, and the status of State Information Commissioner with the Chief Secretary in the state, so that they can function in an independent and effective manner. Now, there was a parliamentary committee recommendation, and it says the recommendation of the Parliamentary Standing Committee was that the Information Commissioner and CIC were to be made on par with the Election Commissioner and the CEC. But this has been ignored. Instead, the State Information Commissioner will be elevated with the Chief Secretary in the state. So, government has its own reasons for bringing this. They are saying that it will act as an independent, it will increase the independence and the effectiveness of the office. However, there are certain section of people who believe that this would compromise the working conditions of the CIC. So, see, this Chief Information Commission, it's a very important office. Why we are saying this? Because we have already observed that it is vested by law with status and independence and authority as the original act was. Now, as alleged, that these proposed amendments, they can fundamentally, dilute the very essence of RTI, and it would also violate federalism, which is an essential part of the Indian Constitution. In fact, one of the basic structures of the Indian Constitution, and undermine the independence of Information Commissioner. So, what we should conclude this, that independent structures like CIC are there to regulate and monitor the government, and they are very, very important. They are very essential. They are very vital for any democratic country which is committed to deepen democracy, enhance good governance, and deliver justice. So it should not be perceived. It should not be perceived in the eyes of people and any section of people as something which is going against the good governance and transparency and accountability of the very office that intended to do the opposite. So the separation of power, which we have also said that some people believe that it's been compromised. It's actually one of the essential feature of what the Indian Constitution talks about, the checks and balances, that one institution checks the other. So it can underscore the independence, and it can be very inversely beneficial to the checks and balances that is envisioned in the Constitution. So it can be seen as a tendency of more centralization of power, and as some people believe that the freedom of expression can be threatened, and it can lead to some dilution of democratic values as well. So this is what this act was all about, and we will meet again with some other video. Happy learning and happy studying.